We're going to start at a minute past the hour. So in 1 more minute. You can see on the chat the people joining from so many different places in the US and many different communities and different media. We're going to start soon, probably about 30 seconds now. Hello, everyone. Thank God it's Friday. All right. Starting in a few seconds. All right, it's 1 minute past the hour. Hello, everyone. Welcome to today's American Community Media Weekly National Briefing. I'm Pilar Marrero, your moderator for today and co-producer of American Community Media's weekly news briefings with my colleague Sunita Sorachi. Today's topic, expanding surveillance of immigrants. At what cost? The US government has steadily expanded its use of surveillance tools, often under the banner of fighting fraud, stopping crime, or detecting undocumented immigrants. But those same tools, from DMV database access and facial recognition to cell phone tracking and data broker contracts, are now building a vast infrastructure that reaches far beyond immigration enforcement. This digital dragnet has the potential to place every American under unprecedented scrutiny. By compiling and cross-linking personal information, the state increases the risk of political targeting, identity theft, and massive data breaches. What starts as surveillance of immigrants can quickly become surveillance of all, eroding the privacy rights of every resident. Our panelists will examine these developments, highlighting the most recent trends under the Trump administration, and talk about what safeguards are needed to protect democracy and civil rights. Our expert panel is Nicole Alvarez, Senior Policy Analyst for Technology Policy at the Center for American Progress, Emerald Say, Associate at Georgetown's Center on Privacy and Technology, and Sophia Cope, Senior Staff Attorney at the Electronic Frontier Foundation. We ask reporters to enter questions in the chat and to panelists, if they have time, to answer them if we don't get to them during the different Q&A sections. We will also try to get them at the end of the panel. And so we begin with Nicole Alvarez, who is Senior Policy Analyst for Technology Policy at the Center for American Progress, and who recently wrote a report entitled, quote, "The Trump administration is using American sensitive data to build a digital watchtower," unquote. Welcome, Nicole.
Thank you so much. I'm going to share my screen. Great. Great. So my name is Nicole Alvarez, and I'm a Senior Policy Analyst for Technology Policy at the Center for American Progress. Thank you, Pilar, for your introduction. Yes, last month I published a report that investigates how the Trump administration is using American sensitive personal records to build what I call a digital watchtower, which is a rapidly expanding system of surveillance that threatens not only the immigrant communities currently being targeted by this administration, but the privacy rights of all Americans. By federal records, I mean the personal information people share with the federal government when they apply for benefits, file taxes, register for public services, or interact with agencies in any official capacity. So you can think of things like your social security numbers, your medical records, your immigration status, your tax returns. So my report focuses on two major developments that are fueling this digital watchtower. First is what I call secondary data abuse. Second is the centralization of federal data systems. And so today I want to walk you through each development and the harms of this expansion and why they demand urgent attention. So let's start with a bit of context. The Privacy Act of 1974 is the main law that governs how federal agencies handle our personal data. It was created after the Watergate scandal when Congress realized just how easily government data can be used for political ends. At its core, the law says that when you give information to the federal government, it should only be used for the purpose you gave it for. This is known as purpose limitation. It also says that agencies cannot share that information with anyone else unless the law allows it in very limited circumstances, or you have given your written consent. Now, there are other privacy laws that apply to specific kinds of data. For example, tax records are governed by the Internal Revenue Code, and health records may fall under HIPAA, but purpose limitation remains the cornerstone of fair information practices across most laws. Now, the
Nicole,
problem with,
the slideshow is not advancing. Is it supposed to be?
oh no, it's still the same page.
Oh, okay. It's just the front page right now.
Oh, is it? Can you see the next slide?
I'm
Or
sorry, I can only see the first slide.
oh, I'm not sure where that's happening. I can see the, give me one second.
Oh, now I see the one about the 1974.
Okay, perfect. Yeah, I'm not sure that
Okay.
happened. Okay, great.
All
Um,
right.
Great. So, the problem with the Privacy Act is that it just has simply not kept up with the times. It is from 1974. It was written before the internet existed, before mass data storage, and before agencies could link massive databases. So today, the law offers very limited accountability when data is reused, when data is repurposed, or when it's shared across agencies in ways that were never expected, which brings us to our first major issue developing under the Trump administration. So
Hold
we're
on,
going to start.
hold on, Nicole. Hold on, Nicole.
Oh,
It's still the slideshow is still sort of frozen. So what I can see is the 1974 slide, but then there's a menu, the drop-down menu that is blocking it, so it's still frozen. I don't know what is going on with this.
hmm.
If you want to just talk without the slideshow, that would be okay. Now, okay. Now the menu. Okay. Click again so the menu disappears. I know.
I'm so sorry.
That's okay. I don't know what's happening.
I can go on without the slideshow.
Yeah, it's okay.
Okay, so
All
sorry about that.
right.
So
It happens.
we're turning to secondary data abuse. This is when information that you provide to one federal agency for a specific purpose, like applying for benefits or paying your taxes, is reused by the same agency, a different agency, or a different entity entirely for a different purpose without your knowledge and consent. So, for example, we've seen the IRS has begun sharing taxpayer data with Immigration and Customs Enforcement to help identify and deport immigrants who have paid taxes in good faith. This is a major shift because this is not what the systems were built for. When these people submitted their information to the IRS, they did so with the understanding that it would be used solely for tax purposes, not for immigration raids. And now that data that was originally collected to support public finance is being weaponized for immigration enforcement. And again, these systems were not designed with this kind of cross-agency repurposing in mind. And although the Memorandum of Understanding, the MOU between the agencies spells out specific requirements and actions that must be followed by both agencies, there is still very little public transparency and oversight around how this is happening in practice. Actually, the IRS commissioner who was appointed by President Trump earlier in 2025 actually ended up resigning in protest over the sign agreement because of the privacy concerns. And unfortunately, this isn't happening in isolation. Similarly, Medicaid enrollment records have been reportedly used to identify immigrants for deportation, even though, again, the individuals involved were engaging with these systems in good faith, often seeking care or simply fulfilling their civic responsibilities. this is effectively turning healthcare safety nets into a surveillance pipeline. And in general, it is a major break from the longstanding norms of privacy and purpose limitation in public data use. So don't know if you can see the next slide, but the harm here, I want to be clear that these practices go far beyond just privacy violations. They actively erode trust in public institutions. Again, when people share their personal information with a government agency, there is an expectation, sometimes rooted in law, sometimes just in practice, that the information will only be used for that specific purpose. So by increasingly repurposing information, like in the agreement between the IRS and ICE, the government is not only undermining that public trust, but it's also opening the door to broader misuse that could eventually affect legal residents and even U.S. citizens. The agreement sets a dangerous precedent because it erodes the IRS's role as a neutral financial authority with strong privacy protections. So in the future, we could see actions to weaponize taxpayer data in other ways, like to pressure individuals and institutions or to retaliate against them. And also because, the IRS databases are not built for immigration enforcement, there's a real risk that American citizens would also be subject to privacy violations or erroneous immigration actions due to simple administrative and data mix-ups. And so the effect is that when people see the government repurpose their information in ways that feel retaliatory or are unpredictable, they begin to opt out. They may avoid filing taxes, they may forego needed medical care for themselves or their children. They may not apply for benefits that they're entitled to. And these are not like irrational choices. They are survival instincts in a system that no longer feels safe. And when people disengage from public systems, those systems inherently become weaker. They become more unfair and less democratic. And this has ripple effects in that it makes it harder for agencies to then serve communities effectively. And ironically, it undermines long-term goals like fraud prevention and civic participation. So it's not just about protecting privacy, it's also about protecting the functionality and fairness of government systems. So I have a chart here that explains actually the tax contributions by undocumented immigrants. I'm not sure if you can see that, but I'll just kind of state.
No, we can't. But
Okay,
please send us your slideshow later so we can send it to reporters.
absolutely. So I'll just explain basically what the stats are, but it's not a stretch to say that the IRS and ICE MOU is likely to dissuade some undocumented immigrants from filing taxes going forward. And if true, this will lead to billions in lost revenue. So the chart is basically showing that undocumented immigrants pay an estimated $90 billion in federal, state, and local taxes. This is data taken from 2022. It is also further estimated that even a 1 percentage point reduction of tax compliance among the overall population would cut federal revenue by $40 billion. It is also important to note that more than 1/3 undocumented immigrants' tax dollars go to payroll taxes dedicated to funding programs that these workers are unable to access, such as Social Security and Medicare. So overall, this reduction in taxpayer dollars is likely not only to impact public services, but also shift that tax burden to other taxpayers. And so I will then proceed to the second development that we're seeing under this administration, which is the centralization of federal records. So we're not just witnessing an increase of secondary data abuse, but also a structural transformation of federal data systems. So traditionally, data is kept in silos. It's siloed within each respective agency, and legal boundaries like the Privacy Act, as well as agency-specific rules, act as barriers that make it hard to misuse sensitive records. So, for example, the IRS manages your tax filings, and the Social Security Administration handles your Social Security records. Very distinct entities with distinct goals here. So these systems had their own rules, security protections, and legal barriers around who could access what. And if one agency wanted another agency's data, it usually requires a formal agreement like the MOU and often triggers Privacy Act protections. And this system ensures that no single part of the government can access every aspect of a person's identity at once. Now, for years, policymakers and technologists alike have criticized that siloed nature of federal data systems, saying that, it hinders efficiency or it limits coordination and makes it harder for agencies to serve the public effectively. But the solution was never to tear down the walls entirely. And what we're seeing today is not careful reform, but a full-scale shift toward data centralization, which again is the process that involves pulling together separate databases from different federal agencies into a single unified system or master database. So instead of each agency retaining separate control, the Department of Government Efficiency, which is driving this initiative, is copying or transferring the raw data into one centralized repository, which creates a single point of access where DOJ staff and potentially other agencies can query across all records at once. You can think of this like merging everyone's like separate filing cabinets into like one giant searchable filing cabinet. And this shift matters because centralization fundamentally changes the rules of the game, right? Under the old system, legal and technical barriers slow down misuse. So this means that the IRS could not casually dip into Social Security Administration files without oversight and vice versa. But under centralization, those barriers are stripped away. And it means that rather than focusing on coordination between agencies that respects existing boundaries, we are seeing efforts to consolidate data in ways that eliminate legal safeguards and reduce transparency. And this kind of consolidation expands the government's capacity to monitor individuals far beyond what was previously possible. When information from different parts of a person's life is combined, federal authorities are able to build detailed profiles that can be used to make high stakes decisions, often without the person ever even knowing. Now, these efforts are often justified in the name of efficiency or fraud prevention, but it's clear that without transparency, limitations, or accountability, it's only going to create opportunities for misuse, both intentional and accidental. And because the public often isn't aware this is happening, there is little opportunity to push back or even understand how one's data is being used. And this is pretty much like going back to, the watchtower metaphor. It's where the government can see more and explain less, and we are seeing less of what the government is doing with our data.
Yeah.
So the bottom line here is that the surveillance of immigrants is just the starting point. History shows us that tools created for surveillance rarely stay in their original box. These practices often begin with politically targeted groups because, frankly, they're easy, right? They allow federal agencies to test their technical capabilities and legal justifications with minimal pushback. But once these systems and practices are in place, it's easy for the scope to quietly expand, which leaves everyone vulnerable, not just the groups that the administration claims to be targeting in that moment, but everyone who has interacted with a federal agency. And that's because the infrastructure that is being built right now, like the practices that we are seeing, such as the centralized databases, the unchecked access, the misuse of sensitive records, it's all designed to scale. And once it's in place, it can and will be used against other groups, such as journalists, protesters, voters, and everyday Americans. Just to give you an example, the longer a centralized database remains in use, the more deeply it becomes embedded in government operations, and that makes it harder to unwind. So newer records will only continue to be added, often without preserving that information, that important information about their origin, their legal protections, or permissible uses. And over time, additional systems may even be designed to interact with or depend on that centralized database, making it even more difficult to dismantle and increasing the risk that it becomes a permanent fixture of government infrastructure. So that's why
Nicole,
this,
can we
yeah,
move on to questions?
yeah, absolutely.
Okay. The first question that showed up in the chat by Richard Ran, um, given rapid advances in AI, predictive analytics, and biometric tools, where do you see surveillance practices heading into the next 5 years if no safeguards are introduced? And I think I talked to one of you, I think it was Emerald, and we talked about the fact that the government has done illegal surveillance before, even without any of these technologies. But how far can it go with these technologies?
Yeah, so we're actually seeing some of that now, right? We're seeing the use of artificial intelligence to determine like Medicaid applications. It's unfortunately the sky is the limit if we do not have safeguards. Currently, right now in the US, we do not have a federal privacy law, which would lay the foundation for most of these issues. And then, of course, we are also lacking an AI accountability law at the federal level. So unless we can establish some sort of foundation for protections, we can expect artificial intelligence really to go in any way.
Yeah. The other, there are several questions about what do we do? What can individuals do about the improper use of private information? What is the way to fight this?
Yeah, so the truth is that the burden shouldn't be on individuals to protect themselves from these systemic misuses. Once your data is in a federal system, especially one that's shared across agencies, there are very few ways to control what happens to it. You can't just opt out of government systems. You need to pay taxes, you need to access healthcare, you need to apply for benefits. That's why we need structural protections, not just individual caution, but with that being said, I think that being informed helps. People should know their rights under existing privacy laws, like the Privacy Act of 1974. They should be cautious about what information they share voluntarily. And most importantly, I think that they should support efforts at every level to strengthen transparency, limit data sharing, and build real accountability into how the government handles personal data, because protecting privacy and just isn't just about protecting information. It's about, protecting the power and agency and the trust in public systems, like I mentioned.
Mm-hmm. Okay. Um, Nestor Fantini has a question. You want to ask your question, Nestor? Nestor Fantini, can you unmute him, or I will read the question? Okay.
I was trying to admit
Okay.
myself.
Okay. Go for
So,
it.
as it has been suggested, the government, and we're talking more specifically of ICE, has a contract with a Paragon that uses the graphite spyware software. So, specifically, can this software read WhatsApp messages, for example? And if so, is there any messaging app that's secure enough to prevent the third parties from spying on the writer, like VPNs, etc.? Thank you.
Yeah,
So,
personally, I'm not aware of the specific program. I don't know if my fellow co-panels um are aware of it.
That is super
yeah,
technical.
I can try to answer this. I'm not a technologist, but we were just talking about this yesterday. So it remains unclear exactly what the government is going to do with this technology. Um, as a first as a legal matter, if they are going to want to use this technology within the United States against persons in the United States, either under a traditional Fourth Amendment law or under statutes like FISA, the Foreign Intelligence Surveillance Act, they have to get some kind of warrant from a court, either a regular court, a federal court, or the FISA court. If they don't, that's illegal. Um, Typically we see the use of spyware in this, like in this kind of spyware used against people in physically in other countries. Um, and so it is concerning if our domestic agencies are using it. So that remains to be seen. As a technical matter, um, what I do know is that the spyware to be effective has to actually be on your device, which means, and usually these are called, they get on the device through what's called a zero-click ex sort of exploit or zero, like it's basically a gap in the software where there's a flaw in the software, like by Apple or whomever. Um, and zero click means that you don't have to like click on a link or anything like that. It's just sort of like sent to your device and is installed, which is crazy. Now, there's a sort of cat and mouse game between the spyware companies and the device companies. And so the number one piece of advice on this that I can give is that if there is an update, a secure like a software update for your device, install it immediately because most of the time it's a security update to patch a vulnerability. And so what I want to clarify is that, but if that spyware is on your device, it sort of doesn't matter if you're using an encrypted service like WhatsApp or Signal, because when you read it, it's not encrypted, right? It's decrypted at your end as you're the receiver, right? So you can see it in plain text within the app. And if that software is already on your device, the software can also see it in plain text. So it can be really hard. I mean, there's a case that my colleagues at night are litigating with El Faro journalists who were subjected to NSO group software by the Salvadorian government. So, it can be really hard if you don't know that it's there. But sometimes, people get hints about weird stuff happening on their phone, and you can send it to a technologist, particularly at Citizen Lab. The folks at Citizen Lab in Toronto are really good at analyzing devices of civil society folks who've been infected by spyware. So hopefully that gives some
Thank you.
context.
Yes, yes. Thank you, Sophia. And Nicole, there's more. I'm gonna get one more question here. And Araceli Martinez from La Opinión. Ask your
Hello.
question.
Yes. I was wondering how can this type of surveillance further complicate the situation for undocumented immigrants? For example, we know that the DMV in California can share information with ICE in specific cases, but if this means that this could it could be expanded and they could have access to information from state agencies. That's my main concern, that they can go and get information, penetrate to the data of state agencies. Could that be possible?
Yeah, I think that's exactly what Nicole was saying. Nicole?
Yeah, so the problem right now that we have with the MOU between the IRS and ICE is just that it can open the door for greater issues. Specifically, there are lawsuits that are, of course, fighting that agreement currently. Back in May, a federal judge refused to block the agreement, but the case is still ongoing. And it's hinging on specific exceptions within the Internal Revenue Code, which deals with the privacy protections around your tax information. And so right now, this specific case hinges on a technicality around how the Justice Department is arguing it falls under a criminal investigation, even though, of course, this is typically a civil matter. So what they're doing is that they're saying that they are seeking this information to find people who are avoiding deportation orders, which is a federal crime. And unfortunately, we just have to take their word that they're not using it to further advance the mass deportation agenda. But yeah, the judge held, that if a valid written request meets the statutory requirements of the exception and the criminal investigation, that the IRS must share that information. And so again, it's a very slippery slope, and it's setting unfortunate precedent if it's allowed to go forward.
Thank you. Thank you, Nicole. Now, please welcome Emerald Se. She's a Justice Fellow she's an associate at Georgetown Center on Privacy and Technology. Welcome, Emerald.
Oh, thank you, Pilar. And yes, my name is Emerald Say. I'm here on behalf of the Center on Privacy and Technology at Georgetown Law. And For some background, for those of you who might not know about the Privacy Center, we are a research and advocacy organization located within the Georgetown University Law Center, and we focus on privacy law and policy and the impact of digital era surveillance on individuals and communities. The center's long-term investigations began by uncovering law enforcement use of face recognition, and then due in part to the overlap between the criminal legal system and the immigration system, the center's research has expanded to include various areas of work, but relevant to today, the surveillance of immigrants and the communities they live in. So two of the Privacy Center's reports are particularly relevant to today's discussion. The first is American Dragnet, Data-Driven Deportation in the 21st Century. And the second report is Raiding the Genome, How the United States Government is Abusing its Immigration Powers to Amass DNA for Future Policing. So continuing the conversation that we've been having, the federal government through the Department of Homeland Security, or DHS, has extensive digital surveillance powers. In American Dragnet, which the Privacy Center published in 2022, we revealed that ICE uses digital surveillance to monitor the lives of a majority of people in the United States. Nicole mentioned this briefly, but one of the findings of that report was that ICE has taken advantage of the information needed to give in exchange for essential services. So when people signed up for water or electricity, the information that they gave to utility companies ended up in the hands of ICE. And similarly, when people applied for driver's licenses, the information that they gave to the DMV also got to ICE. And then following this research on the extensive surveillance dragnet that ICE has created by accessing data sets that contained detailed personal information, we went on to research the ways in which the federal government has expanded genetic surveillance. In 2024, we published Raiding the Genome, and this report details the drastic expansion of a DHS program to take DNA from thousands of people every single day. We found that the federal government has been collecting DNA on the assumption that people will commit crimes in the future. So what happens is that federal agents will collect DNA under immigration powers. And the DNA samples are then used to create profiles, and those profiles are added to a federal policing database called CODIS. Law enforcement across the country can search the profiles in this database to identify people who have committed crimes in the past. But we also found that the federal government has defended DNA collection from immigrants as a way to predict who might commit crimes in the future. So over time, these vast digital surveillance powers have grown over time. As Nicole mentioned, the current administration has gathered data from various federal agencies, including the IRS and the Social Security Administration. And then with respect to DNA, the Privacy Center has continued its research in that area and has learned more about DHS's DNA collection program since we published last year. And we released updates this past July, if you're interested in looking at that. But in addition to our original findings, we found that DHS was adding more profiles to the federal criminal policing database at a rate much faster than we originally anticipated. That profiles were added regardless of whether a person committed a crime or had been charged with the crime, and that they had been added regardless of the person's age. So these massive surveillance powers, whether they be our personal information or genetic information or biometric information, this power is now in the hands of an increasingly authoritarian government. And we've seen that government already use those powers for not only immigration enforcement, but also for political repression. We've seen government agents arrest and detain activists and union leaders. And when elected officials have attempted to check the current administration's abuses of power, we've also seen the federal government arrest and even bring criminal charges against those electeds. And while all this is happening, private technology companies stand to profit, and they're doing so at the expense of the public. So to illuminate this a little bit, in American Dragnet, we found that between 2008 and 2021, ICE's annual surveillance technology spending ballooned from $700 million to $400 million per year. And since then, the surveillance industry has continued to grow. At this year's Border Security Expo, DHS Secretary Noem called for more government partnerships with private companies, and we have continued to see these private companies be awarded multi-million-dollar contracts with the federal government for these types of technologies. And the last thing I want to say here is that this surveillance puts everyone at risk, not just immigrants. There are certainly some communities that are more at risk than others, but we know that the current administration has already targeted and detained people regardless of their immigration status, and that it has already used its surveillance tools available for immigration enforcement to suppress free speech and punish political dissent. So this surveillance, in addition, as Nicole mentioned, this creates an erosion of trust in the government. It makes people afraid to go to work, afraid to send their kids to school, afraid to seek medical treatment until it's very urgent, and it makes them less likely to overall participate in our society. So it truly impacts everybody.
I'm sorry, I was muted. Sorry about that. I was just thinking when you were talking that those profiles that they're creating, could someone that reports a crime be also profiled? Like there's a question in the chat by Aitana saying, are undocumented women at higher risk of arrest and deportation if they report domestic violence, for example?
So based on my research, I'm not aware of that happening, but that is certainly a fear amongst people within that population, that people who are subject to surveillance are afraid of engaging with any institution that keeps records. So for particularly sensitive communities and those communities who rely on institutions for essential services, they are less likely to report, less likely to seek help when they need it.
Thank you, Emerald. And another question by Caesar Nukum, who asks that I asked the question for him. What have the agency heads supposed to protect privacy done? Are they doing enough to protect privacy? I think some resigned early on. Has the Congress acknowledged the privacy intrusion, and have they done anything to protect privacy of everyone? So is anyone doing anything?
So there's certainly more that can be done. These abuses continue to occur. As Nicole mentioned earlier, there is no federal data privacy law to set the baseline for a lot of these privacy violations. And there's currently a fight over whether to regulate emerging technologies under the category of artificial intelligence. And relevant to my research on DNA collection, that those findings have recently been the subject of oversight letters by an oversight letter from Senator Ron Wyden to the DOJ, and it's also caught the attention of Representative Presley. So this is certainly an ongoing conversation, and I would certainly encourage the public to engage, learn more, and reach out to electeds because this is very, very important.
Yes, I'm sorry. There's a couple of questions asking about the impact on Asian immigrant communities or Asian American and Pacific Islander communities. One of the questions says Asian immigrant communities often face language and cultural barriers. Does that make them more vulnerable to hidden harms from expanded surveillance? And the other question is, how have this surveillance tactic and data abuse affected Asian American communities in particular?
So I am not that is not like a focus of my expertise, particular to AAPI communities. But what I can speak on is that that language barrier is certainly something that is difficult for people to engage and reach out to institutions to learn more about their rights to begin with. I I'm not certain whether that might be distinct from other immigrant groups. But again, that is not the focus of that is not the area of my expertise.
Yeah, probably similar to other groups as well. Okay. All right. There's many more questions, but I'm going to move on to our third speaker. Thank you so much, Emerald, and stay around. And then we're going to go to Sophia, Senior Staff Attorney for the Electronic Frontier Foundation, Sophia Cope. Welcome, Sophia.
Hi, thanks, Pilar, and thank you for having me. So I'm going to talk, I don't have slides, but I'm going to talk at a high level about social media surveillance of immigrants, and then also device searches at the border, which impacts anyone wanting to come to the United States legally, and also American citizens. So, and I suspect some of you already know this, but starting out with social media surveillance. So back in the first Trump administration, the State Department initiated a rulemaking, which was ultimately finalized. And what that did is that added a question to the visa application. This actually was later added to the ESTA form for visa waiver travelers, asking folks for their social media handles that they've used over the prior 5 years. And obviously the goal of that is to, actually for the consular officials to actually look at any public social media and then evaluate whether or not a visa should be granted or ESTA form should be, should be approved. There was a lawsuit, or there is a lawsuit related to this that the Knight Institute, the Knight First Amendment Institute at Columbia brought. We filed an amicus brief in that case. It went through appeal because originally it was dismissed, but essentially it's a First Amendment or free speech challenge to the collection, arguing that there's a great chilling effect and sort of inhibition or inhibiting, I should say, of freedom of speech, both by the applicants, but also their sort of associates in the United States. That appeal did not go so well, but it's possible that the case might move forward, kind of depending on what the lower court does on remand. I can go into details if you want to hear the doctrinal issues. But essentially that just means that it's been going forward, that this question has been on the forums for the better part of a decade. And to Pilar's one of her main points is that, well, how does this impact even Americans here? That, I mean, we've argued that American citizens who might be the colleagues or the family members or friends of the visa applicants, that they themselves might be chilled in not wanting to speak out publicly on certain things for fear that they're either going to affect their loved one's ability to even get a visa, or that they themselves are going to be caught up in the surveillance. Because notably, the government has not said that they aren't looking at people in the networks, the social networks of the main targets. So relatedly, I'm sure you all have know this and have covered this. We've also seen now in the current Trump administration, not only are they looking at the social media of applicants to the United States, visa applicants, but actually non-citizens, primarily, well, it started out with student visa holders who are currently here in the United States. We've also seen them expand their scrutiny of lawful permanent residents and people with other statuses. And I mean, and most recently, they announced that they're going to look at the sort of, I guess they're calling it sort of continuous vetting, like they're going to engage in continuous vetting of people here in the United States, sort of all visa holders here in the United States. And they have said that that includes looking at their social media. So obviously that is going to have a much larger impact than just looking at applicants. People are here in the United States, like I said, on various statuses, including, or I should say, various kinds of visas. A lot of them are members of our communities and our colleagues and friends and family members. And the chilling effect is going to be, and there anecdotally we understand that it's much greater, right? That people are scrubbing their social media, or choosing not to speak out on things, particularly political issues, not want to speak out against the Trump administration. And then their loved ones who might be U.S. citizens are also being chilled because they don't want to risk their loved one's visa being revoked or other status being revoked. And again, they don't want to perhaps risk themselves being swept up into the surveillance and having that data collected and stored in government databases. And then, per the conversation we've been having, potentially used against them later on down the road. We've seen the government initially this year talk about looking at student visa holders and their views on Gaza and Palestine, and of course the war between Hamas and Israel. But then more recently, we've seen them expand the subject matter of looking at social media and potentially punishing people or revoking statuses for a slightly broader concept of anti-Semitism. First, it was sort of pro-terrorism, then sort of pro-Palestine, then it's anti-Semitism, and then it's even gotten as broad as, just sort of a general hostility toward American values and American culture, which is ridiculous because all of that speech, frankly, even pro-terrorism speech, hey, I like Hamas or whatever, is actually protected by the First Amendment to the U.S. Constitution, as long as you're not engaging in something that is not protected, such as speech that is meant to incite imminent violence, or speech that can be considered to be a true threat toward another individual, where they're in fear of being imminently violently harmed. So this is a problem. This is a huge problem. Lots of people's freedom of speech has been impacted, and just FYI, like EFF, we've written about this a lot. We've filed comments. The USCIS recently had a comment period related to this. We've filed many comments in the past. The Brennan Center has led a lot of this work as well. So there's been a lot of work trying to push back on this. Like I said, the Knight Institute at Columbia. So a lot of civil society groups have been trying to push back on this surveillance, but unfortunately, it's here. It's here for the time being. I'm going to shift over to device searches at the border. I work on this issue and have worked on this issue for a very long time. I could talk about this for hours, but I'll try to be brief. Essentially, what we're talking about is CBP, Customs and Border Protection's ability to search the cell phones, laptops, or other devices of travelers legally crossing at ports of entry. As I said in the beginning, that this implicates really any traveler crossing what's called the U.S. border, but it can be an international airport or land border or seaport. And yeah, it could be really anyone. It could be U.S. citizen, it could be lawful permanent resident, it could be someone who is here on a, like I said, a work visa or student visa, or someone's here just coming here for the first time on traveler's visitor visa. And just give a quick overview of kind of some kind of policy issues and practical guidance. CBP has an operative policy. It's from 2018 related to device searches. I can share that link with you or have Pilar share it with you. Essentially, it allows or grants CBP, they've granted themselves the authority to search devices in two ways. One is what they call a basic search, which is a manual search, so sort of just mousing, tapping, scrolling, etc., through a device or folders and files and things. The other type of search is a forensic search where they actually plug another device, another computer into your device, use sophisticated software to either download the entire hard drive or do sophisticated data searches and analyses like on, of your data on your device. Since you all are journalists, I will note that they do call out in the policy journalist confidential information, but it's a very sort of lukewarm nod to the idea that some information, like such as confidential source information or journalist unpublished work product, might be protected. So as a practical matter, if you are crossing a border and you get pulled in secondary inspection, you can tell them you're a journalist, and that sometimes has let them, encourage them to sort of pull back on what they're trying to do. What else? So the most important sort of data point, or I should say personal characteristic that is relevant to device searches at the border is immigration status. Because CBP will say that you must unlock your device or provide the passcode so they can inspect the device. But as a practical matter, if you're a US citizen, you have to be let back into the country. They cannot deny you re-entry into your own country. And so you have the most, as a US citizen, the most leverage to refuse to comply with that request. Now, that doesn't mean there's not going to be consequences. You could be detained for several hours, miss a connecting flight, miss an event, etc. You could also have your device confiscated indefinitely. If they're particularly motivated to get into it, which means they would let you leave the border and then keep it for weeks or months. So that's something to keep in mind. For lawful permanent residents, they also technically are supposed to be let back into the country, but we have seen this administration be particularly interested in revoking the green card status of people, unfortunately. And so it's just a little bit tricky for them. They could potentially try, not to comply, but that may lead to some kind of escalation that could lead to, some investigation and questioning of their green card status. And then for people who are here on a visa or here on through the visa waiver program, who are, sort of all the other non-citizens, essentially, if they don't comply, they can be denied entry to the United States. And so people really have to think about, how much do they need to get into the country. If it's for vacation, maybe they don't care that much. If it's for a really important work event or, a family emergency or something like that, maybe they do care. We have a lot of information on our website about how people can sort of think about, as a technical matter, how to prepare their devices to cross the border. And in fact, we just published with the Freedom of the Press Foundation a checklist for journalists. So to the extent that you as journalists are concerned about your own devices, that checklist is on our site. And again, we can get the link to Pilar for that. We have other general information for travelers. And the two sort of main things we talk about are to limit the data on your device, and also for the data that is remaining, because maybe you do need to have certain data on your device accessible when you travel, that to protect it. But that assumes that you have decided that you're not going to unlock your device for a CBP officer if you're pulled in secondary inspection. If you feel comfortable doing that and you've decided you're not going to, you're not going to do that to unlock your device, then you want to make sure that you have, encryption engaged, strong passcodes, have it powered down, and most importantly, make sure your data in your phone, laptop, whatever, is backed up, either to a cloud or some other device, maybe that a small little thumb drive you sent in the mail or something like that, to make sure you don't lose your data. So that's like a really high, sort of quick overview. One important policy point of CBP that I want to call out is that in the 2018 policy, they do explicitly say that they will not look at information in the cloud. They will only look on data that's resident on the device, meaning that they have to put, the officer has to put the device in airplane mode or otherwise disconnect it from the internet. And they can only look at the data that is accessible without internet access. In terms of social media, if you have private social media, so like a Facebook account that's only accessible to your friends and family, just note that sometimes even when the device is in airplane mode, some data will still have been copied or quote cached on the device. And so you just have to think about, well, maybe you just delete the whole app. Sort of linking this back to social media, if you are traveling here on a visa, some people do either log out of or delete their social media apps on their phone, but just be aware that because you've already had to disclose your social media handles, your public social media handles, some of that information may have already been reviewed in the granting of your visa. And so when you present yourself to CBP, which is, first you dealt with the State Department, now you're dealing with the DHS, it's possible that, and we've heard anecdotes of CBP actually having access to some of that preliminary social media data that was available publicly. So if then once you travel and you sort of either made your social media private or have deleted the apps from your phone, it's possible you might still get questioned on stuff that was accessible sort of away from your device, just on the internet prior to your travel. And so sort of be prepared for that. So that's all to say that deleting a social media app on your phone is not necessarily going to get you away from scrutiny by a federal agent once you arrive at the border and are seeking sort of in that moment entry into the United States. Yes, other countries do this, and some of them are worse than the United States. So if you are traveling to another country, you should definitely try to investigate what their device search rules are and prepare accordingly. So like I said, I could talk about this forever, but I'll just leave it there because I know it looks like we're coming up on the hour. And happy to take other
Yeah, there's a
questions.
bunch of questions, but so is there any evidence that any of this surveillance has been used specifically on journalists? Like, for example, what they're publishing or what they're posting on social media, etc. And do you think that's something that may happen eventually?
No, it definitely, yeah. So we hear anecdotally, and sometimes it's actually in the press. There was a Wall Street Journal reporter that was stopped at LAX sometime before the pandemic and was questioned because she was a Middle East reporter, and they were trying to get some information about some of her contacts over there. And this is a key point that's related to that, is that ostensibly CBP and sometimes ICE at the border as well, through HSI, not ICE like domestic and forward, but like HSI, which looks at cross-border issues. Ostensibly, they're looking at people's devices if there's a problem with the person, because typically customs enforcement is like, I think if you look at someone's luggage, I think you might be smuggling drugs. I'm going to look in your luggage, right? The suspicion is attached to the person. And in fact, for forensic searches, there is this reasonable, and I didn't say this earlier, but there's a reasonable suspicion requirement that the person has potentially violated a law that CBP can enforce. Whereas for a manual search, there's no suspicion requirement at all. It can be completely random. It can be on a hunch, whatever. But what we know in practice, and in fact, we litigated this issue several years ago with ACLU, and we were able to conduct a deposition of CBP and ICE officials, and they readily admitted that they will seek to search the device of a traveler, not when the traveler is the person who's the target of the investigation or is under suspicion, but because they think the traveler might have either valuable intelligence, sort of generally speaking, or has information on someone else that they're associated with that is the subject of interest, is a subject of interest to the government. And that to me is absolutely crazy, because you're basically, the government is violating the privacy of travelers to get at other information that is of interest to them. And it's a way to get around the Fourth Amendment. There is generally speaking, if you're at the interior of the country, the government has to have a warrant to search any kind of private information, whether it's your private notebook or your private cell phone. They have to get a warrant. But unfortunately, the courts have created this border search exception to the Fourth Amendment warrant requirement. Not all cases, like in the Fourth Circuit on the Mid-Atlantic and on the West Coast and the Ninth Circuit, there are some heightened rules around this. But generally speaking, courts have also sort of deferred to the government and allowed them to get around the warrant requirement, which is absolutely ridiculous. So in terms of advocacy, we've been trying to get a bill passed for a long time to require a warrant for all device searches at the border. But anyways, to get back to the journalist issue, absolutely. I mean, we have seen, again, not because a journalist is necessarily the target of investigation, but because they know, the government knows the journalist has been talking to people, has sources and contacts that are of interest to the government. And we've absolutely heard anecdotes of the government stopping people and
We
trying
are
to get more
against,
information.
sorry, we are against the hour. So thank you to you three, and thank you for answering questions in the chat as well. Let's go around the panel and have each one of you just tell us very short, 30-second soundbite. What should we reporters covering this issue be focusing on? Nicole?
Yeah, so I think that right now it's important to highlight that Americans deserve a full account detailing how these systems were built and used. And this means, congressional, independent, and criminal investigations should be undertaken to uncover the extent of this administration's data consolidation and secondary data abuse, as well as to determine whether federal agencies have violated the law and the public trust. And so I think that that is where not the most important, but I think that is an important place where journalists can shine light into a call for action. As far as like the general public, like I said, I think that we need to lean into modernizing these laws that we have already in place. But yeah, I think that Americans deserve a full accounting detailing how these systems were built and used.
Okay, Emerald?
Yeah, I'd like to echo Nicole's remarks. And I'd also like to say it's important to highlight the impacts of surveillance on people who are being directly, who are on the other side of these technologies, of these different policies. But while we're looking at those impacts, I think sometimes what is lost is the local advocates on the ground who are coming together, trying to create community resources for folks to lean on during this time.
Thank you so much, Sophia.
So I'll say a couple of things. One that often gets lost is this question of effectiveness, and I'm a constitutional lawyer, so I care about the big picture as well. But sometimes down at the very detailed policy level, this question of effectiveness gets lost. And so with the social media surveillance, well, I'll say the caveat that this administration seems to just not give a crap one way or the other. They just want to get rid of immigrants. But if you press them, they will try to come up with some kind of legitimate reason for doing it. And they'll often say, anti-terrorism or something like that. But it remains to be seen that they're actually like effectively thwarting terrorist attacks or, finding criminals or like in terms of justifying this mass surveillance to get at, a handful of bad actors. So I always appreciate when reporters really press the government to prove effectiveness for any kind of program. The other thing I will say is that intra-agency, so inside agency oversight mechanisms have been severely damaged by this administration in terms of undermining the ability of, let's say, the inspectors general or certain oversight boards or advisory committees to like PCLOB, the Privacy and Civil Liberties Oversight Board. All of these mechanisms, which is not, it's anyways, it's a governmental, it's not inside one agency, but you know, it's still important. But inside an agency, you have like the DHS Civil Liberties and Civil Rights and Civil Liberties Office, the Privacy Office, um, uh, and then the Inspectors General. Where are these people? What are they doing? And a lot of times they've been fired, or they don't have a quorum, like on PCLOB, or you know, they're not there, or they feel like they have to cower to the administration and rubber stamp everything. So I would just really, really encourage reporters to push to figure, you know, to get the answers as to like why are these intra-agency accountability mechanisms not up and running? If the government doesn't have anything to hide and they think they're doing everything great and to make America great again, then they should not be afraid of oversight through these mechanisms. So I think they're super important, and outsiders like journalists really need to keep pressing them on this.
Thank you, Nicole, Emerald, Sophia. Sorry for abusing your time. We're 5 minutes past the hour, but this has been fascinating. Thank you for sharing your knowledge with us. And thank you to all my colleagues for so many great questions. Have a good weekend, everyone.